Доброго дня, шановні пані.
Good afternoon, ladies and gentlemen. Ukrainian Crisis Media Center continues its working day, and we are happy to welcome you here in the press room and online. Today we have representatives from the embassies to discuss the situation around the draft law 2689. And with this, I give the floor to the first speaker. Good afternoon, everybody. Our current topic is 7 years of impunity for the war crimes. What Ukraine has today, we will discuss the draft law about the crimes against humanity and war crimes which are committed at the territories occupied by Russian Federation. In Ukrainian criminal code, we do not have such an article about the crimes against humanity, while the war crimes are stipulated rather obsoletely, and that's why almost 5 years ago the human rights activists and lawyers had formed a working group which drafted the bill number 2689, which was submitted to Parliament, and today we will discuss this draft law and the price that our people have been paying for the passage of this law. I'm pleased to give the floor to Mr. Gunduz Mammedov, Deputy General Prosecutor of Ukraine. Mr. Mammedov, the floor is yours. I understand that Mr. Mammedov he is connected. Good.
Есть контакт, да? Добрый день.
You can hear me. That's good.
Добрый день, приветствую всех.
Good afternoon, everybody. I'm happy to welcome.
Меня не может не радовать, что сегодня предметом обсуждения становится тема именно переходного правосудия в Украине. И ответственность за военные преступления как одно из основных компонентов. Я твердо убежден, что на сегодня в условиях международного конфликта с Российской Федерацией эта тема должна быть одним из основных приоритетов нашего государства. Международный конфликт, как вы знаете, к сожалению, который продолжается уже 7-й год, и 7-й год продолжается совершаться военные преступления. Это умышленные убийства, пытки, исчезновение людей, нечеловеческое обращение, незаконная депортация, перемещение, принуждение службе в оккупационной армии, использование живых щитов и многое-многое другое. И Украина как государство, в частности, прокуратура, обязаны предпринять все меры для необходимого и эффективного расследования этих преступлений. Ну, сегодня Уголовный кодекс, как вы знаете, содержит всего одну статью, нашу знаменитую 438-ю, которая является несовершенной и носит бланкетный, ссылочный характер и включает в себя практически все виды военных преступлений, что на практике усложняет ее применение. Хотя в некоторых случаях она и удобна для применения, но я бы хотел сказать о том, что откровенно только для тех людей, которые достаточно, скажем так, глубоко знают международное уголовное и гуманитарное право. Свидетельством всего этого является то, что вот за весь период конфликта нами направлено в суде всего 2 приговора по данной статье. и около 20 направлено в суды обвинительных актов. При этом, как вы сами понимаете, эти преступления совершаются больше, чем есть в официальной нашей статистике. И детализация состава преступления и их четкое регламентирование в Уголовном кодексе является крайне необходимой для обеспечения принципа неотвратимости наказания, привлечения к ответственности лиц, виновных в совершении военных преступлений, преступлений против человечности и выполнения прежде всего Украины своих международных обязательств. Это намного облегчит нам нашу работу и прокуратуре, и органам досудебного следствия, и судам. Поэтому выражаю искреннюю надежду на то, что наш парламент в ближайшее время все-таки примет в целом законопроект 2689 об имплементации норм международного гуманитарного и уголовного права. И я этого жду достаточно давно лично, начиная с 2016 года. И для нас, для Офиса Генеральной прокуратуры, в частности, прокуратуре Автономной Республики Крым и Севастополя, прокуратуре Донецкой области и Луганской области это очень важно. И мы надеемся, что желаю вам всем нам плодотворной работи і інтересної дискусії. Спасибо огромное.
Величезне дякую пане Гундузу Маммедову і в тому числі за постійну підтримку зусиль правозахисників, науковців, експертів для просування цього законопроекту, який необхідний українським органам національного слідства і суду для розслідування і притягнення до відповідальності винних у скоєнні міжнародних злочинів. Я попрошу сказати мені, чи приєднався до нас Денис Монастирський. Наскільки я розумію, поки ні. І я хотіла би передати слово одному із авторів законопроекту 2689 Антону Корynевичу, постійному представнику президента України в Автономній Республіці Крим.
Дуже дякую, Олександро. Доброго дня, шановні колеги. Доброго дня, шановні представники посольств іноземних держав, акредитованих в Україні, і міжнародних організацій, громадянського суспільства.
To representatives of the diplomatic corps, of embassies, and good afternoon to the human rights activists. I believe that the draft law 2689 is the urgent matter for discussion. I'm today in a bilateral capacity, so to say, as a contributor to the draft law and as a person who today is responsible for persecution for the war crimes in the prosecutor's office. And I believe that this draft law was an attempt to incorporate the up-to-date standards in this area to Ukrainian legislation. I fully support Mr. Mammedov that this 7th year of the conflict between Ukraine and neighboring country. It's a shame to have just one blank and referential article about the war crimes in our criminal code. Again, the 7th year of the armed conflict between the Russian Federation and Ukraine, we absolutely do not have such type of a crime in our criminal code as the crime against humanity. Any European state has it, we have to recognize that such crimes exist and that we should have this article in our criminal legislation and incorporate it into the legislation. The draft law, which was mentioned, number 2689, it is not the draft law which was produced upon somebody's request or to satisfy somebody's interests. It's just a very quality legal text. During the past 7 years, when the Crimea is occupied, the Russian Federation violates lots of human rights in Crimea. They persecute people, they arrest them, they apply tortures, people are kidnapped, people are humiliated, people are forced to enroll to the Russian army service. Crimean Tatars are continuously and violently persecuted. In all that situation, Ukrainian authorities need to produce this instrument, and based on the instrument be able to persecute the war criminals and the criminals against humanity. As of now, any lawyer opening criminal code of Ukraine is unable to understand what is considered to be the war crime in Ukraine. He has to go further to the international conventions, etc. As for the crimes against humanity, we recognize it in general as a nation, but you cannot find this term, the crime against humanity, in our criminal code. That's why we understood that we have to make the novelties in our legislation, and with the assistance of our international partners, we were able to produce quality legal texts, and now based on that novelties in legislation, we will be able to persecute and bring to responsibility all those offenders against humanity who committed that sorts of crimes in Crimea and in the east of Ukraine. And I hope that the Verkhovna Rada of Ukraine will demonstrate its ability to understand the importance of the issue, the importance of responsibility for committed crimes against humanity and committed war crimes, and will pass this law number 2689. It may seem that this is just a draft law, but this is the draft law about better standards of judiciary, of better standards of human rights. And we have to show that we are European state, and the impunity for criminal offenses and crimes is not existent in Ukraine. All the stakeholders who are to ensure the transition justice. I mean, all the presidential envoys, the Ministry on Occupied Territories, they all understand the importance of this draft law for the transition justice. Thank you for your attention. Thank you, Anton. And continuing your idea and coming back to the blanket article 438, I would like to mention that Ukrainian investigator or Ukrainian lawyer dealing with Article 438 has to muster more than 134 additional international documents which deal with the essence or with the language of this article in practice. This results in a situation that agents, investigators, and lawyers may not take into consideration that those pieces of international legislation which do not deal with the Ukrainian law. I'm happy to give the floor to Mr. David Donat Katin, Doctor of Science, Secretary General of the Parliamentarians for Global Action, PJ organization. The floor is yours.
Thank you very much, and good afternoon to everyone. I'm very honored to be part of these proceedings, and in fact, it's really impressive to see how the authorities in charge of public prosecutions, in charge of the representation of the president of Ukraine in respect of Crimea, and also members of parliament are represented in this briefing. I really would like to pay, first of all, tribute to the leadership of Honorable Monastir, who paved the way for the speed-up legislative process that led to the adoption in September in first reading of the draft law that we are commenting on today. My understanding is that there are amendments that have been tabled in the Rada that might be detrimental to the overall design of this legislation. And I think Oleksandra from the Center of Civil Liberties really highlighted the practical importance of this new legislation. You cannot have laws that do not reflect international law under the rule of law. It becomes very complicated for practitioners to defend the rights of victims, to apply the rights of the accused, to discover the truth against facts that can be qualified as crimes under international law, the most serious crimes of concern to the international community as a whole, in respect to which we have an entire body of international humanitarian law and international criminal law to apply, a body of law that does not call into question the issue of retrospective application or retroactivity of the criminal law. So I'm really asking myself and asking the expert participants here, where are these amendments relating to the coverage of past events? Where are they coming from? They seem not to be legitimate amendments, because as we already know, there are international institutions investigating the situation in Ukraine, and they would not look at whether there is a domestic law applicable at the time in which alleged atrocities took place. There are international treaties that are binding on Ukraine. I'm just mentioning here the European Convention on Human Rights, Article 7, and the International Covenant on Civil and Political Rights, which clearly specifies that it's punishable conduct in every member state jurisdiction, every conduct that is criminalized either under domestic law or under international law. There is no doubt that genocide, crimes against humanity, and war crimes have been criminalized since 1945, 1984 for example, torture, 1977 insofar as the additional protocols to the Geneva Conventions are concerned, and you may go also back in time insofar as customary law is concerned. So there is no doubt that any of the crime committed since the crisis erupted in Ukraine, both in the Donbass and in Crimea, fall under temporal jurisdiction of Ukrainian courts. So these new law should be modern, should be in line with what we have as the law of Ukraine, and should not contain any ambiguous formulations insofar as the retrospective application of this norm will be relating to. My other concern here regards universal jurisdiction. Universal jurisdiction is really residual tool in the toolbox of states to fight impunity for the most serious crimes. We are not advocating for massive or widespread application of this principle. However, we have recognized it is essential, it has been essential, for example, in a recent court case in Koblenz, Germany, to deal with an individual traveling from Syria into Germany who is closely associated with the Assad regime that perpetrated thousands and thousands of crimes against humanity and war crimes with impunity in the bloodiest armed conflict of this century, the armed conflict in Syria. Do we want our own countries, I'm from Italy or Germany or Ukraine, to become a place where you can travel and you can enjoy impunity and live a new life without being prosecuted for atrocity crimes when you may be found responsible of those? Now, the provisions in the current law allows, don't obligates, allows Ukrainian prosecutorial bodies to apply the principle of universal jurisdiction as a last resort. I would argue that that's a useful policy decision by the Rada, and it's also in line with the practice of essentially all the European Union member states. My final point here is very political. So I would advocate against the amendments that have been proposed to weaken the law 2689. I would call upon here to all the diplomatic, the members of the diplomatic community who are attending today, including those who are representing here the European Union, its member states, the United Nations, other intergovernmental bodies. It's there, and the OSCE, for example, or others who are committed to the rule of law, human rights, and the fight against impunity. We consider, on behalf of Parliamentarians for Global Action, that Ukraine is one of the most countries in which change can be effected toward the vision of a rules-based international order. The law 2689 is an essential proof that there is political will towards that change. And I believe it's a unique opportunity for all the diplomatic representations in Kyiv and also from those in capitals to encourage, support, stimulate that the Rada makes this very important legislative reform. It is also one that is already accepted under the constitution of Ukraine in the new Article 124 adopted by the past parliament. It is also fully implementing the EU-Ukraine Association Agreement, which is a major treaty that is bringing about a lot of reforms in a number of other fields, like the fight against corruption or economic reform, the market paradigm, and others. So I would really strongly support any intervention that you may consider appropriate towards Ukrainian legislators, and our group in the parliament comprises of members of parliament from the ruling party and also some members of the opposition. We would be absolutely engaged in this effort too. Thank you very much.
Дуже дякую, пану Давід.
Thank you, Mr. Katin. Currently, we work on the final amendments after first reading. We had received comments from some political parties, and part of those amendments from political parties are able to ruin the all essence, the whole architecture of this law. And I'm very happy that Mr. Katin mentioned the what Mr. Katin mentioned about retrospective application of this law, because many MPs who offered amendments to the law, they wanted to prevent application of that law for the early periods. The passage of the law, of course, is very much needed for Ukrainian people, but it is also needed to comply without international commitments. And I would like to give the floor to Ms. Virginie Amato, regional coordinator from the coalition under the International Criminal Court. Ms. Amato, the floor is yours.
Thank you, Oleksandr. I hope you can hear me. Well, good morning, good afternoon, Excellencies, colleagues. Well, it's a pleasure to be with you, and thanks to CCL for inviting me today. I wish I would be there with you in Kyiv, but oh well. My name is Virginie Amato. I'm coordinating the work of a network of civil society organizations advancing the cause for international justice in Europe, with NGO members in more than 150 countries around the world, including many in Ukraine, promoting accountability and redress for victims of international crimes at the national and international level. A lot has been said already, so I'll keep it brief. But of course, for several years with our members in Ukraine and others like PGA, we've urged Ukraine to fully align its domestic laws and policies with international standards, because it can equip national authorities with aspects of the legal framework necessary to support effective investigation and prosecution of those crimes. Like it's been said, it's the essence of this system of international justice, where states have the primary responsibility to do so, to punish the perpetrators of these crimes and provide redress for the victims. So the adoption of this draft law we're discussing today is a very important first step in that direction, under the leadership of MP Monastyrsky, and thanks to our colleagues from civil society and experts. This can definitely build on the creation of the specialized war crimes department in the Prosecutor General's office, headed by Prosecutor Mammedov. So, well, David already mentioned this, but I would have a very simple, perhaps, message today to Ukraine's partners, states, and international regional organizations to vocally support this process. Your government and organizations should make accountability for international crimes a priority in relations with Ukraine, and make sure that the government and the parliament demonstrates a serious commitment to victims. Domestication of international law can strengthen the domestic justice system and respect for human rights and rule of law more generally. Importantly, it will also send a strong message to the people of Ukraine and to the international community that the country is committed to bringing perpetrators of international crimes to justice and addressing the suffering of victims. But as we said earlier, it's also been a commitment of Ukraine in various international and European instruments and fora. The European Union, the UN, the Parliamentary Assembly of the Council of Europe, and several states individually have recommended the government and parliament to bring Ukrainian laws in line with international standards. But so far, there's been no clear benchmark or timeline that has been set and at this point respected. So now it's really the time for states and international and regional organizations to make sure that the authorities and parliament take concrete action urgently. We do believe in this regard that indeed the European Union and EU member states have a crucial role to play to fight impunity in Ukraine and to support those efforts. Ukraine, like David noted, the EU-Ukraine Association Agreement includes provisions related to implementation of international law, including of the Rome Statute of the International Criminal Court, but also to judicial cooperation in criminal matters. The lack of these had also recently, for example, a practical impact. Last year, Ukraine applied to become part of the European network of specialized war crimes units, investigators and prosecutors dealing with genocide, crimes against humanity and war crimes nationally, which is called the EU Genocide Network. This network includes EU member states, representatives, but also US, Canada, Norway, Bosnia, and Switzerland representatives as observers. And the lack of proper legislation, Rome Statute implementing legislation, prevented Ukraine to benefit from joining this network of practitioners. The network did not accept the application of Ukraine to be an observer because it has not implemented the relevant crimes in domestic legislation. So it invited Ukraine to reapply after that that step has been taken, and also once Ukraine ratifies the Rome Statute. So we still hope that the adoption of the bill can be completed by the end of the year. That's very urgent at this point. We will continue to advocate for justice for the victims and continue to support our members in Ukraine. We also really hope that governments, regional organizations, and others can continue to support these efforts from civil society and human rights defenders who are relentlessly fighting for justice. And finally, allow me to mention that we would really hope also that in addition to this, the continued call for Ukraine to join the Rome Statute, another commitment to combating global impunity, especially for a country like Ukraine. So I will stop here. Thank you very much.
Дякую, пані Вірджині.
Thank you, Ms. Amato, for your continuous work aimed at overcoming impunity for international criminals in Ukraine. With this, I would like to give the floor to a person who is a deep expert and has a huge practical experience of application of legal provisions, who contributed to the draft law 2689, to Mr. Scott Martin, the managing partner of the Global Rights Compliance.
Thank you for the introduction and good afternoon to everybody. Again, I'm Scott. I'm from Global Rights Compliance. I've been working on this bill since its very first iteration in 2016 with Human Rights Agenda. And it's really a nice moment to look at this in the most optimistic way that we're getting really close to passage. I've been asked to speak about two matters briefly today that have arisen as the RADA considers the IHL reform bill or Bill 2689. And first is the potential exclusion of command responsibility from the bill as a mode of criminal liability. And then the second, a bit more broadly, the practical implications of further delay to the passage to the bill. So firstly, I'll start with excluding command responsibility. It's important to remember that command responsibility is one of the core fundamental tenets of international criminal law. And in the context of international criminal tribunals, it's one of the most frequently used modes of liability. And I expect that as we hopefully advance in Ukraine from preliminary examination into investigation, I expect that this mode will also be heavily used. And now, at least for a year now, there's been one core concern, and a legitimate one by the Rada, that I want to address very briefly. And it's their concern that command responsibility is not a form of individual criminal responsibility. And so it fails to satisfy that requirement under international criminal law. And so, or more broadly, they're concerned that you should only be responsible for crimes individually and not collectively. And to be fair, if this were true, I'd fully support that objection. And I would also argue for removal of the provision from the draft bill. The problem is that it's not. And neither military commanders or any other individuals in authority are responsible for the crimes committed by any other persons under this mode. Instead, they're responsible for failing to control subordinates that they have command and control over, who later committed crimes that they should have or actually knew about, or they failed to prevent that crime, punish the crime after it was committed. Failing to include this response, so I would say that should not be a concern. And more broadly now, regarding command responsibility, failing to include this mode of criminal liability could lead to widespread impunity for crimes that a person should be held responsible for under international criminal law. Think about a scenario. Are the only culpable parties for a crime committed those that are actually perpetrating the crimes, such as lower level perpetrators in the command hierarchy in the military, for example? What about if a commander, a high-level Russian commander, for example, was fully aware of a crime that was about to be perpetrated, had the authority to stop it, and did nothing? Command responsibility addresses that gap in the Ukrainian criminal code's legislative infrastructure. And that needs to be punished, but in that scenario, perhaps it would go unpunished. Beyond this, there's an important practical consideration. As everybody knows, the International Criminal Court's prosecutor's office is considering whether to launch an investigation into crimes right now in Ukraine. If they investigated and they determined that a commander of Russian, a separatist commander, or even a Ukrainian commander was allegedly responsible under the command responsibility mode, they may issue an indictment. Now, the ICC is a court of complementarity, or one that defers to the willingness and ability of the national courts to address a criminal act. And in doing so, the ICC allows Ukrainian courts to investigate and prosecute the case if it sought to do so. But by failing to include command responsibility in the Ukrainian criminal code, it could lead the prosecutor's office in The Hague to decide to go forward with the case because there were no provisions in the criminal code of Ukraine to prosecute these guys, these individuals. The effect of this without the command responsibility provision would deprive Ukraine of the possibility to try perpetrators directly under its jurisdiction, something not only more effective from a time and cost perspective, but also which enables Ukraine to be fully involved and take ownership over the crimes committed in its territory. And so for these reasons and others that have been discussed over the past years by many of the people in this conference right now, I respectfully urge the Parliament of Ukraine to include command responsibility in this draft bill. Now, more briefly and lastly, I want to discuss the practical implications of further delay to the passage of the bill. First, states, and not the ICC, are principally responsible for protecting and promoting international criminal justice for victims of crimes committed in Ukraine. The ICC can only handle a certain type and certain number of cases. And while it is a world court, it's quite a small court. With more than 13,000 killed in this conflict, credible allegations of torture, forced conscription, illegal imprisonment, and other forms of violence and discrimination, the ICC simply cannot handle all the criminal prosecutions. This falls to the state to have all the requisite tools in place to handle these responsibilities. Second, and relatedly, international criminal law is a form of accountability, without which leads to impunity for perpetrators of some of the gravest crimes known to humankind. Without the amendments proposed in the bill, There are impunity gaps in Ukrainian legislation that could lead to someone avoiding individual criminal responsibility. Finally, having the appropriate legal infrastructure will more fully empower Ukrainian practitioners and prosecutors to assist the ICC in prosecuting leadership cases. Launching domestic cases leads to the discovery of evidence that can be relied upon by the ICC. It can assist with the development of case theories, and it can complete plea deals where lower level perpetrators of crimes implicate higher level officials in the planning of such crimes. All of this can assist the ICC if and when it launches criminal prosecutions against high level government and military officials. Thank you for the opportunity to speak.
Дуже дякую, пане Скотт.
Thank you very much, Mr. Scott. Thank you for your brilliant explanation how the exclusion of the command responsibility would result in grave consequences for Ukrainian legislation and its ability to persecute for the crimes committed on occupied territories. Now I would like to give the floor to a person who contributed much. This is Mr. Konstantin Zadoya, adjunct professor in criminal law from the Kyiv National University, named after Shevchenko.
Thank you. For me, it is really important to speak today before the members of the embassies. In my speech, I would like to say that this draft law clearly identifies the terms of war crime in the legislation of Ukraine and envisages a number of provisions that should prevent impunity. And international legislation, this is not only about war crime, this is also about other crimes, and it requires that the states provided punishment for these crimes. And this draft law in this respect, I believe, fully reflects these obligations. It contains provisions concerning prevention and those who perpetrated military war crimes or crimes against humanity, that these people should be brought to justice. And also that probation is excluded, and also limitations period should not be used for such crimes. And also I would like to raise the issue of amnesty. Ukraine, in accordance with the Minsk agreements, should carry out amnesty concerning the part of the military conflict in Donbass, and also amnesty is the instrument of transitional justice together with the criminal persecutions. I believe that this issue of amnesty will rise, and in the regulation of this armed conflict, and this amnesty will happen. And the parties of the Minsk agreements, but this amnesty should not cover international crimes, and the practice, the international practice shows this, and amnesty should not be used in such cases. And this draft law directly prohibits amnesty in cases of war crimes and crimes against humanity. Because unfortunately current legislation allows amnesty in such cases, and this draft law eliminates this gap in legislation. And this draft law clearly identifies what crimes and war crimes and crimes against humanity, and this will create clear and transparent process. And in the course of amnesty, when they will implement this amnesty, they will understand whether this is an international crime or whether this action is not international crime. Current legislation creates grounds for such contradictions. So, some decisions are difficult to take, and the amnesty should provide for reconciliation, and this draft law should clearly identify what actions are military, are international crimes, and it provides a proper responsibility for it. And it will prevent distortion in implementation of law of amnesty. Maybe this is not, it won't be done in the nearest future, but it will be done. And previous speakers said about the importance of this law, and this will help us in the nearest future and in the in prospect. So I would like to say that I participate in this process of implementation of international humanitarian law. I have been doing this starting 2015, and I would like to state the draft law 2689. This is not a chaotic or spontaneous decision. This is a result of the long process. And Ukraine has been dealing with this issue for a long time. This is important. And also, I'm a teacher of law, and I'm really glad that many Ukrainian and international experts were involved in the creation of this draft law. Only part of this group of experts participate today in discussion, and this is a result of collective efforts of lawyers. This draft law transparently was discussed with the public repeatedly, and considerations of bodies of power were taken into account, and the opinion of universities and other institutions were taken into account. This was important for the task that we had. This draft law is an expert document, and it is ready to be accepted and to be efficiently used in practice in the future. Thank you very much, Konstantin. I would like to give the floor to Oleksandr Hryshchenko. He is a former prisoner from Lugansk. And I would like to say that when we speak about these legal matters, we should see real people behind those words. And we do all this. We are fighting for the adoption of this draft law to help those people who suffered. Good afternoon, dear ladies and gentlemen. I'm Oleksandr Hryshchenko. I'm the resident of Lugansk Oblast, a former prisoner. Today's meeting, for me, to some extent, is really important. I was born on the 21st of August. On the 13th of November, I will be celebrating my second birthday, because on the 13th of November 2014, I survived after death penalty. Several hours before physical destruction that they wanted to commit, they wanted to throw grenades into the basement where we stayed. But we were helped out of this basement. Today it was said that all those crimes, war crimes and crimes against humanity, that this sounds rather abstract. Unfortunately, I had to pass through hell of captivity. And I saw all this with my own eyes. And because of absurd accusations, I was captured in the street and I was thrown to the basement. I was humiliated and I was tortured. During the first several days, I thought that I just went insane, because what I saw, I couldn't even imagine that such things can happen. I saw that people were tortured terribly because they said some words. For example, that they support unified Ukraine, and this person was tortured to death before our very eyes. And I saw that women were brought to interrogations, but they were raped instead. I saw that the girl was brought to positions of the militants and she was raped there. And inhumane conditions of detention were created for elderly people who were seriously ill and they just died because of this. And people were seized and terribly tortured because militants believed they had some suspicions about these people. And periodically, dead people who died of torture, they were brought out of the basement. I saw that people were really hurt by this torture, and some people were urgently hospitalized to hospitals, and urgent operations were made, and some organs were taken out because there was internal bleeding. So I do not want to describe all those terrible sufferings. I would like just to stress that this really happened, and unfortunately, it is still happening. Due to different estimates, there are hundreds of people in captivity, hundreds of Ukrainian patriots and military men. And according to my approximate estimates, thousands of people went through these basements where people were tortured. I'm deeply convinced that adoption of this draft law 2689 should become the top priority for our legislators, because without this draft law, we have impunity. We feel that these people are not punished. And if we adopt this law, this will bring justice for those people who suffered this hell. And fortunately, they remained alive. And I would like to call on all those who were involved in the preparation of this document to do everything possible in order that this draft law 2689 is adopted in the nearest future. Thank you very much. Thank you, Oleksandr. And from me, I would like to thank you that for these 5 years and other people who survived captivity, in temporarily occupied Donetsk and Lugansk Oblast and in Crimea, that you support this campaign to provide justice. And I understand that we ask you to meet with people's deputies to tell them the story. I understand that this is really painful for you to speak about it. Oleksandr Hryshchenko, he has a very peaceful profession. He is a veterinarian doctor. So you understand that even really peaceful people, they are kept in those basements just for nothing. So this practice of capturing people, this practice continues in Donbass. That's why this draft law is not about the past. It is also about present and the future, because people who commit those crimes, they are convinced that there will be impunity for them. They and Konstantin Zadoya, he said that these people, they believe that they will be absolutely under this amnesty, and this draft law that will provide important aspects so that these criminals would not be under this amnesty, and these people won't be able to hide behind some abstract Putin, and the responsibility will be and the punishment will be brought. Now we are holding this press conference, and people are in isolation and in other detention places, and people are people torture these citizens of Ukraine, and we hope that we'll be able to save people's lives. And Denis Monastersky is one of the authors of this draft law, head of committee of the Verkhovna Rada on law enforcement, and he does a lot to promote this draft law in the parliament. Unfortunately, there was delay, and he, as a head of a commission, he cannot be with us now, but I'm really glad to give the floor to one more author of this draft law, Victoria Mozgova. She is the assistant of the head of the committee.
Hello, thank you very much. Hello to everybody. Thank you for this possibility to be on this meeting. And first of all, want to say great thank you so much for supporting the process of process of adopting this bill. It's very important for us, and your support, your work really helped us a lot to go through the first stage of hearing. And we really hope a lot that we will be the same successful in the second hearing. My chief, the head of the committee, he is now chairs the committee, another committee, and unfortunately, it's this meeting that his meeting really is delayed, but it's almost finished, and I hope that he very soon will be with us and can say and answer more clear of your probably some of your questions that will deal with this situation, what we have now, what's happening in the committee. But I wanted to say that now we are in the process of, we have some amendments from deputies. It's not a lot, it's very good situation, because it's 123 amendments. For these kinds of draft, it's really a very small, very small, not difficult situation. And you're completely right. During this meeting, you say a lot about the main problems that we have with this draft. It deals with universal jurisdictions, responsibility of commanders and other superiors, retrospectivity, and almost it's the basic problems that can make a lot of problems with this draft, but we understand that without these main positions, this draft will not be so successful when we'll adopt. Today, we really have the situation that in general, deputies understand how it's important for Ukraine. They really wanted to support that. Some of them under political manipulations, under the situation when some political parties, some deputies, because of different interests, try to make not really truly information about this draft, try to say that it's against people, against our soldiers, that it will make them harm, that's why we can't adopt this law. And they manipulate situation around ICC, and we try to explain that it's for Ukraine, it's very important to have this draft, because first of all, we will show the international society, we will show the ICC that Ukraine can by itself to make a trail in these kinds of crimes. But we really hope that the second hearing will be successful too. We plan that until the end of this year, it will be. Now we will have, this month mostly, we will have some short meetings with different deputies, mostly with the deputies that send their amendments to discuss, because we are analyzing each amendment to explain why we not support or we support, and we really try to make this draft better. And thank you a lot for help that you gave us, because it's really give us the possibility to make the draft better. And also we have recommendation of ICC, like a work variant of that recommendations, and we already made our amendments that can make this draft better. Also, we have the situation that we adopted the second protocol to GAA Convention that deals with culture, sorry, I don't know this word in English. And we create a new article that will be like implementation this second protocol of GAA Convention, and that's why we really support that the end variant of this draft will be really good example of work that we did now. And of course, in the future, when the practice process will start, and our law enforcement bodies, our courts, the practice of using this law will show that we need some small changes, for example, to do. Of course, we will do that, but I hope that really what we have now will be adapted, and we can really to explain to the deputies and explain to our society that this draft of law, first of all, try to support our soldiers, our civilian people, and it's not have a goal to broke the rights of our soldiers. It's really for support our soldiers, for support people who was tortured by in Donbass, and who have now the really who now in the situation when our law enforcement bodies and our courts can't do nothing, can't we really have the situation where the people who committed a crime against our people will not have any criminal responsibility for what they did. And that's why we hope that really everything will be successful. As I saw now, unfortunately, my chief, Denis Monastyrski, is still on meeting. I can see it online too, because he on the Zoom meeting, it's like committee meeting, and unfortunately it's still going. But if you have any questions, I can to answer until he still on meeting. Thank you.
Дуже дякую, пані Вікторії.
Thank you, Victoria. I would like to open now Q&A session. We have a possibility to connect those who would like to ask a question via Zoom session. You may choose either to speak in Zoom or to write in chat in Zoom. And in this case, we will read it loudly and you will get your answer. So please, those who are here in the room, you may raise your hands. Good afternoon. I'm Alexei Klyashtorny from the Fund of Ukrainian Defense. I have the first question to Oleksandra and to everybody who may wish to answer. As far as I understood, the attention of today's press conference, press briefing was focused on the draft law, which would allow to bring the war criminals to responsibility. And now my question, which is neighboring to this area, how about persecution of offenders according to the legislation which is effective in Ukraine as of today? Many participants of the terrorist operation perished or were killed in result of shellings, and those shellings might be qualified as terrorist acts. And following the logic, each terrorist act should be investigated. The criminals who initiated that terrorist act should be brought to responsibility, even for the cases when perpetrators or offenders are beyond the territory of Ukraine. Whether you have any information whether such investigations were initiated, whether such criminals were established, and whether they were charged for the commitment of such crimes. Thank you for your question. If somebody wishes to answer, you may interfere. I will start answering this question. This is the issue when we discuss not just regular criminal crimes, but the crimes which could be qualified as the war crimes. This is the problem, that we try to persecute the offenders for the general criminal crimes, not as a war crimes. For example, the case of Volnovakha shelling, and when the bus was targeted, and also some shellings on the crowds of people at the checkpoints, etc. These were intentional crimes. If you try to investigate and persecute them as a regular crime, then this does not reflect the violent nature and fear of people that they experienced, the terror, terrorist intensity, so to say, of those crimes. And moreover, the war crimes or crimes against humanity are not, they do not have the limitation period for investigation or charges. While some regular criminal crimes could have the limitation period for investigation and persecution, while the war crimes could be investigated even after 30, 40 years later. The next consequence, the regular crimes the regular crime offenders, they could enjoy the amnesty, while the war criminals are subject to the international conventions and the International Criminal Court practice, which suggests that they cannot be subject of amnesty. Such crime as the Volnovakha shelling and shooting, shelling of a bus should be qualified not as a general criminal crime, but as a crime against humanity or a war crime. The next argument. Quite often we read that one of the militants is detained and when you read in mass media that this militant just raped women at the checkpoints, and he is charged not for the war crime, but he is charged for ordinary criminal crime, which does not reflect the gravity, the degree of gravity of that crime. Also, I would like to inform you that a year ago in the prosecutor's office, a special department was formed which investigates the international crimes, and those investigators from that department, they are very much awaiting for the passage of the law 2689, which we are discussing today, and they keep saying all this time for almost a year that without this draft law they would be unable to work in total. David, can you speak?
Yeah, thank you. Only very briefly on the issue of terrorism, because of course this is not only something debated in Ukraine, this is debated all over the world. The problem with treating war crimes or crimes against humanity as terrorism is that we don't have an international law definition of terrorism. So you call terrorists your enemies, the Russian Federation calls other enemies terrorists, and so on and so forth. In this way, those who are committing atrocity crimes, they think if we win the war, they are the terrorists, not us. So this is the politicization of the law. Every one enemy is a terrorist. I mean, we know what terrorism is. If there is a bomb in Kyiv aimed at terrorizing the people of Kyiv, that's terrorism. If there is an extremist decapitating a teacher in Paris, that's terrorism, because the goal of terrorists are desperate people who want to terrorize the population with the goal of some subversion one day. This is not what is happening in Donbass and in Crimea. You don't have desperate people. You have well-concerted armed organization conducting campaigns to gain territorial control, and by doing so, they also commit war crimes, crimes against humanity, and other violations of international humanitarian law. You want to call the law with the correct name. So I am when I was in Kyiv in the past years during the Poroshenko government, I realized everything was about counterterrorism. This is not counterterrorism. This is an armed conflict that is being fought where Ukraine is victim of another international crime called the crime of aggression. Let's call by the correct names with legal definitions what we are dealing with. Otherwise, we run a risk that we are competing about who's going to win, not who's going to apply the law to everyone equally. And the victims' rights will not be served. Let's call torture, torture. Let's call rape, rape. Let's call extermination, extermination. Let's call the crime for their real names. Terrorism is a very politicized area. I don't really would like to see a law-abiding nation like Ukraine to be really blocked within that framework. Thank you.
Дуже дякую, пане Олександре. Нам надійшло питання в чаті, я його озвучу.
We had received a question via chat. Who is able to answer? What MPs suggested? Who were those MPs who suggested to cancel the irrevocability of punishment? As far as I know, these were representatives from the opposition platform and from the European Solidarity. So, Victoria, about cancellation of the amendment about crimes, war crimes committed by some moment in time. Victoria perhaps cannot hear us.
I'm here. I can answer officially. We have 3 amendments from 4 deputies who proposed to cancel this part in the draft. They are the deputies Hryshchenko, Ionova, Mamka, Zabrodsky.
І вони належать до якої політичної сили? Цікаво.
What political force do they represent?
It's different. I can check, but give me a second to be European Solidarity, and it's one person of. Give me a second. Give me a second. Sorry. We'll say you for all.
Я думаю, що ми повернемося до цього питання, коли Вікторія.
We'll come back to this issue a bit later when Victoria will find
I'm already found. Just opening. It's European Solidarity, as I said. Again, European Solidarity. And the Opposition Platform for Life.
Так, я не помилилася, це Європейська солідарність.
Yes, it was oppositional platform and European solidarity. They believe that the war crimes and crimes against humanity committed during 2014-2016 should not be persecuted. It's a surprising position, but nevertheless. I'm Sergei Kotnyakov from Man Inform and Successful Country platform. I agree with Oleksandr and with all the speakers. I come from Mariupol, from the Donetsk region. I heard many stories about war crimes. What are the biggest obstacles for passage and implementation of this law? I recollect how OSCE monitors described a lot of war crimes committed by the RDL, and although Ukrainian party also committed that and mentioned that they were unable to monitor all those crimes. Whether we should mention the names of those people who prevent this draft law from passage. I would like to readdress this question to my colleagues who have been promoting the passage of this law. If you wish to take the floor, please raise your hands. I am giving time for translation. Perhaps I will start answering this question. If you wish to interfere, please feel free and raise your hand. I came to conclusion that indifference is the main obstacle. This is not bad intention, perhaps, but indifference. Those who are victims of tortures, they are not visible in Ukraine. Those who stand for the legalization of old cars brought to Ukraine, they have strong organization. They are very much visible. They organize rallies near the parliament, while those victims who are weak, who were tortured, who have very painful experiences and memories, they are not organized. They are suffering silently. I communicated with people who were terribly tortured. They were raped. Their hands and legs were cut. They were made blind, etc. So I had all those terrible experience of terrible communication, and I definitely know that the biggest thing they want to revive the hope that justice exists there is justice in this world, but they are vulnerable, and we have to become their voice. Not only experts, not only representatives of international organizations, but each human being has to become a supporter of this draft law number 2689. Unfortunately, people in power, they are not very eager to support the law, but we all as a society should be interested. I may assure you that for people in power, there are always much more pressing, much more important draft laws than this. That's why for 7 years we have been experiencing these delays with the passage of this law, while the victims, suffering victims, they remain silent. Unless you wish to add something, we are ready to finish our briefing. I would like to thank to all the panelists who contributed to this panel, who were present here in this room, who participated via Zoom platform. For 5 years, we are involved in this process, and we try to push forward the law which had to be passed long ago. I would like to underscore the importance of this law, and I would remind you what Ms. Amato said, that the support should be public. David, the floor is yours. I think you wanted.
Thank you, Oleksandra. Just 1 minute before you, of course, close, just to say that Parliamentarians for Global Action next week will continue a project that took place the last time 2 years ago in the Rada in Kyiv, which is the Consultative Assembly of Parliamentarians on the ICC and the rule of law. We will discuss with many actors, stakeholders, judges, prosecutors, state officials about the problems affecting the global fight against impunity and the opportunities we have notwithstanding the pandemic. And we really hope that the message can come to the world community from the Ukrainian parliamentarians that they are ready to move forward with this important legislation. We think that if this will be adopted, it will place Ukraine really as one of the best countries in the world in harmonizing its domestic law with international legal obligations. And we do believe, as we can see how unfortunate certain decisions have been made in the past, when in the 100 years anniversary of the Armenian genocide in 2015, the president of Armenia decided not to join the Rome Statute as it was recommended at the time. Now we see what is happening in Nagorno-Karabakh once again in terms of victimization of civilians. So being part of international treaties, implementing domestically one's obligations is the way to prevent and hopefully deter and curb and reduce the scourge of international atrocities. I really hope that the Ukrainian law can become a model in the region and worldwide. Thank you.
Дуже дякую, пане Девід. Пані Вікторія.
Денис Анатолійович, щойно закінчився комітет. Якщо є можливість, він зараз підключиться.
Denis Monastersky has finished his conference in Zoom in the parliamentary committee. He is joining to us in a moment.
Будь ласка, вам слово.
Денис, я give the floor.
Я бачу, що ще підключається.
He's trying to connect.
Ah,
Please, Denise, turn on the mic. We're listening.
Доброго дня, чи мене чути?
Good afternoon. Do you hear me? Yes.
Я вітаю всіх
Good
на
afternoon, everyone.
представницькому високому заході. Я радий
This is
бачити
really important high-level
колег, з
event.
якими ми працювали над
I'm really
законопроектом
glad to see
20.
those colleagues with whom we worked on this draft law 2689.
Як ми і говорили з вами
As we've
минулого разу,
said last
подібні
time,
зустрічі, що ми маємо провести повторну зустріч після прийняття в першому читанні даного законопроекту. Ця зустріч зараз у нас відбувається. Фактично, я можу сказати, від комітету в нас подані 123 пропозиції поправки до законопроекту. І робоча група секретаріату, а також представників громадськості працює над тим, щоб ми якомога швидше дійшли не тільки фактично там певних форм ідеальних, але і компромісів по ряду питань. Я скажу, що основні правки і дискусії, які точаться щодо законопроекту, стосуються кількох питань, а саме універсальної юрисдикції, відповідальності військових командирів і прирівняних до них осіб. Я думаю, ви чули обговорення під час прийняття в першому читанні по цих питаннях, а також перехідних положень, що стосуються і передбачає застосування даного закону до подій минулого. Власне, ми бачимо в комітеті можливим розглянути ці поправки, попрацювати з фракціями до грудня місяця, і десь в середині грудня можливим бачимо винести його, пропонувати його на голосування залу Верховної Ради. Це десь до кінця грудня місяця винести в зал. Від мене особисто, як від голови комітету, від моїх колег, я також прошу і хочу підкреслити особливу вагу позиції активних учасників, представників громадянського суспільства, представників з наших міжнародних партнерів в підтримці даного законопроекту. І я звертаюся з відповідним проханням після того, як буде напрацьовано це таке консолідоване рішення по цим позиціям, підтримати його публічно, звернутися відповідним зверненням до очільників фракцій з тим, щоб вони підтримали його прийняття вже в цілому. Я сподіваюся, звичайно, це оптимістичний сценарій, що в цьому році вже цей законопроект і закон буде прийнятий і буде направлений президенту на підпис. Я знаю, що ви вже майже понад півтори години працюєте. Я перепрошую, що підключився пізніше, бо тільки буквально кілька секунд тому завершився засідання комітету. Знову ж таки, дякую вам за підтримку. І я сподіваюся, що ми швидко і ефективно пройдемо той час, який в нас є, для того, щоб напрацювати спільне рішення. Дякую вам.
Дуже всім дякую. Чи всі, хто хотіли висловилися, шановні колеги? Я на всяк випадок запитаю. І тоді ми закінчуємо наш брифінг і дякуємо вам. Будемо вас інформувати як про результати засідання комітету, так і про винесення в зал цього важливого законопроекту, на який чекають десятки тисяч людей, які стали жертвами воєнних злочинів.